Takeaways from Trump's Supreme Court win: he stays on ballot, but his legal peril is just starting. Former President Donald Trump gained a clear win at the U.S. Supreme Court on Monday, which unanimously ruled that states don't have the ability to bar him or any other federal candidates from the ballot under a rarely used constitutional provision that prohibits those who engaged in insurrection from holding office. The decision shuts down a push in dozens of states to end Trump's candidacy through a clause in the 14th Amendment written to prevent former Confederates from serving in government after the Civil War. But it may open the door to further electoral uncertainty, exposing more state officials to disqualification under the provision and setting up a constitutional showdown should Trump win the election. Facing 4 separate criminal trials, Trump's legal peril may just be beginning. The most significant thing the court did Monday was to overturn a Colorado Supreme Court ruling from December that Trump was not eligible to be president because he violated the Insurrection Clause, Section 3 of the 14th Amendment. This will also stop efforts to kick him off the ballot in Illinois, Maine, and other states. Had the Supreme Court had let the Colorado ruling stand, it could have triggered a new wave of litigation that might have left Trump disqualified in many states. The High Court avoided addressing that politically contentious issue of whether Trump played a role in the Jan 6 attack on the U.S. Capitol that would have barred him from seeking office. The ruling is almost devoid of references to Jan 6 or insurrection and doesn't address whether Trump committed such an act by sparking the attack on the Capitol. Instead, it focuses on the technical, procedural question of who gets to decide an election challenge under Section 3. All 9 justices agreed that is the purview of Congress. One possible outcome that the case presented was the prospect of unelected judges disqualifying the man dominating who has already received hundreds of thousands of votes in the nominating process. But another potential nightmare is that if Congress is the only entity that can determine whether a presidential hopeful is indeed disqualified for engaging in insurrection, that it makes that determination on Jan 6, 2025, when required to certify a possible Trump victory in the presidential election. The High Court shut down the first possibility, but may have left the door open to the second one. Last week, the court agreed to hear Trump's appeal of a federal ruling that he's not entitled to immunity from criminal charges for his attempt to overturn the 2020 election. Trump's trial on those charges was originally scheduled to begin Monday, but has been postponed because of the battle over his immunity challenge. The justices' discomfort over being put in the middle of the nation's partisan divide came through in a brief but notable concurring opinion by Justice Amy Coney Barrett. Though one of the court's conservatives, she didn't agree with the majority's ruling that Congress can only enforce Section 3 through legislation. The court's ruling shuts off using Section 3 against federal officials, absent action by Congress, but it leaves open the ability of states to use the provision against their own state officials, noting there's a rich record after the Civil War of just those sorts of actions. Few observers expected the Supreme Court to keep Trump off the ballot, but he's facing far more perilous legal road ahead. The first of Trump's criminal trials for allegedly falsifying business records to pay hush money to an adult film actress during the 2016 presidential campaign is scheduled to start in New York later this month. The former president is also appealing a New York judge's ruling that he pay $355 million for fraud committed by his businesses, and verdict that he pay a writer $83 million for defaming her after she sued him for sexual assault. 2 more cases are more likely to come later. In Atlanta, where Trump faces state charges for his 2020 election plot, and in Florida, where he's tentatively scheduled for a May trial on improper retention of classified documents after leaving the presidency, but the trial date is expected to be postponed.